There is an article in the text and the context section on gay marriages. Since this topic has been covered already multiple times, we will not get into it until the final judgment of the Supreme Court comes on this. But there's something written in the article which is very crucial. The author begs this question: should laws be reflection of social morality? The connotation in this question is: should laws be reflection of social morality or constitutional morality? So that's going to be the first topic of our discussion today. UPSC in 2019 in GS paper 4 has asked this question: what is meant by the term constitutional morality? How does one uphold constitutional morality? In 2021, UPSC again asked on constitutional morality directly. In GS paper 2, constitutional morality is rooted in the constitution itself and is founded on its essential facets. Explain the doctrine of constitutional morality with the help of relevant judicial decisions. We will see some of the judicial decisions in the course of our discussion. The point is, it's an important thing, and explicitly or implicitly, the questions are asked every now and then. First, let's do a quick comparison of constitutional morality and social morality. Constitutional morality is based on the principles and values enshrined in the Constitution. It is adherence to the spirit and the conscience of the Constitution. And social morality is adherence to the principles and values that are held by the society or community in which the individual lives. The source of social morality are the social norms, social moorings, customs, religion, traditional values. Constitutional principles will guide constitutional morality, and the social principles, in the form of customs, traditions, beliefs, they will guide the social morality. Constitutional morality will be universal in nature. It will reflect the moral absolutism. And social morality, of course, will vary from community to community. It will reflect moral relativism. Since constitutional morality is universal, it will be binding on all citizens, including the machinery of the state. But social morality, of course, in the modern nation state will not be binding on individuals or the state or its agencies. For the functioning of modern democratic society, constitutional morality is considered essential. It ensures the rights to the citizens, which are fundamental for individuals to be part of the state. Social morality many a times are also good. They contribute to the healthy existence of democratic setup as well, but sometimes they can be oppressive. They may restrict the rights of individuals. The concept of constitutional morality has been an integral part of Indian Constitution since its inception. Dr. B.R. Ambedkar, the chief architect of our constitution, he believed that constitutional morality was the key to the success of Indian democracy. He defined constitutional morality as a paramount reverence for the forms of the Constitution and for the methods of the Constitution. Justice D.Y. Chanchud has observed that constitutional morality is adherence to the principles of the Constitution even when it goes against one's personal beliefs and interests. And with that spirit, he is heading the bench adjudicating on the matter of gay marriages. The celebrated Justice Rohinton Farley Nariman, he has observed that social morality cannot be a valid justification for denying constitutional rights. And this observation is reflected in many judicial pronouncements. Both constitutional morality and social morality, they both seek to ensure harmonious living in a society. And in society like India, which has long and rich history of civilization made of diverse traditions all coming together, there's a huge sense of social morality. But there is a potential conflict between the two, as social morals may be parochial. It may be prejudiced and violative of principles of justice, equality. It may not guarantee dissent. And there are many laws in India that reflect the sense of social morality. There is a social stigma associated with single male adopting a child, especially a girl child. And you see the adoption laws moved in the direction of these social morality. Even the Assisted Reproductive Technology Bill or the Surrogacy Bill that promotes use of assisted reproductive technology for heterosexual couples, even for single women, but not for single men, not for LGBT community, not for couple in live-in relations. They also adhere to the social morality that single male or LGBTQ community, they are not suitable to raise a child. It is also suggested it is also suggested that social morality is more suitable for a group that is homogeneous, and constitutional morality is more suitable when there are more than one group living together. In a pluralistic society, social morality is what the majority believes in, and the constitutional morality is to weave together the different beliefs, different values, customs, practices together. When India became a nation state after independence, the ideals of liberty, equality, fraternity set out in the preamble, they became the fulcrum around which the diverse traditions could be woven together. The constitutional morality, as reflected in Part 3, Part 4A of the Indian Constitution, they try to weave together different traditions and customs with a strong bond. For instance, the freedom of religion under Article 25 to 28 against potential social moral view that privileges one religion. Similarly, abolition of untouchability under Article 17. It rejects the social moral of ritual purity and pollution. It affirms human dignity and worth. Protection of minorities under Article 29 and 30. They prevent tyranny of majority based on social morals. It protects dissent. It celebrates diversity. The directive principles under Article 38 to 51. It gives constitutional obligation to achieve justice to enforce moral principles of equality against class and gender inequalities sanctioned by social morals. There are many judicial pronouncements overruling social moral claims to uphold privacy, sexual rights, freedom of speech. You know the judgments, striking down practices of triple talaq, the adultery law. But the idea of enforcing the social morality began with the enforcement of constitution itself. It was profoundly mentioned even in the Keshav Nanda Bharti case. The Supreme Court of India held that the basic structure of the constitution cannot be amended. And one of the reasons given was that it would violate the principles of constitutional morality. In the famous Shabrimala judgment, Supreme Court has observed that freedom of religion must give way to the values of liberal constitution. In the same judgment, the court also observed that individual freedom prevails over perpetuated group rights. In the Navtej Singh Johar case, Supreme Court has observed an individual's right to develop one's individuality against the demand of social conformity must be recognized. Majority opinion does not become law of the land. Social morality cannot overshadow constitutional morality. That's the bottom of the bottom of the bottom line. Social morality, as per the present rulings of Supreme Court and the standards set by the judiciary, cannot overshadow constitutional morality. In the adultery judgment or the Joseph Shine judgment, Supreme Court observed Section 497 subordinates women and creates a dent on individual identity of women. So that's how the constitutional morality differ from social morality, and social morality cannot overshadow constitutional morality. But sometimes the interpretation of constitutional morality can be problematic. For instance, in the Shabrimala case, court ruled that closing the temple gates to menstruating women is a violation of right of equality. But what the courts, according to many, failed to recognize is the freedom of belief of certain section of people. In this case, the freedom of belief of devotees of Lord Ayappa. That's also the constitutional right. So this tussle between the social morality and constitutional morality will always be there, and both continue to shape the laws of the land. But coming back to the question, should laws be the reflection of social morality alone? The answer obviously is no. But solace can be found in the words of Dr. Ambedkar that will guide our future course. Constitution of India is not mere lawyer's document. It is a vehicle of life, and its spirit is always the spirit of the age. And he agreed that constitutional morality is not a natural sentiment, it has to be cultivated. We must realize that our people have yet to learn it. So I'll leave you with this question that UPSC asked in 2019. What is meant by the term constitutional morality? You must understand this very well by now. But the second part of the question, how does one uphold constitutional morality? As Dr. Ambedkar says, it has to be cultivated. But how? That we haven't discussed. That's something that you must think about and put some pointers at least in the comment section. The newspaper today is flooded with article on the Supreme Court judgment that came yesterday on the floor test that was conducted in the Legislative Assembly of Maharashtra, which caused shift in the government in the state. And you'll read various articles on the various aspect of the judgment, beginning from the role of the governor to call for the floor test to the role of the speaker in the manner and the way the floor test was conducted, and the role of Election Commission of India as well in giving the symbol and recognition to a particular faction of Shiv Sena. We will begin our discussion concerning the observation of Supreme Court on the role of governor, then we'll switch to the role of speaker, simultaneously discussing the aspect of the observation made by the Supreme Court on the parameters that Election Commission of India must consider before recognizing a particular faction with the symbol and the name of the political party. So, beginning from the role of governor, we'll look at the observation that the Supreme Court has made in the role of governor calling for the floor test. Supreme Court has noted that the governor was not justified in calling up Mr. Thackeray to prove his majority on the floor of the House because he did not have reasons based on objective material before him to reach to the conclusion that Mr. Thackeray had lost confidence in the House. You must take a note that the Indian Constitution does not explicitly mention the term objective material in the context of calling for a floor test. However, this term objective material has been used by the Supreme Court in several judgments related to the power of the governor to call for the floor test. And the most important of them is the S.R. Bommai, the very famous S.R. Bommai versus Union of India 1994 case. In this landmark judgment, Supreme Court held that the governor's power to call for a floor test is not absolute and must be based on objective material. The court held that governor cannot act on vague or speculative grounds but must have concrete and specific material to support their decision. This is the judicial interpretation of the role of governor vis-à-vis calling for a floor test. Now, same observation has been made by the Supreme Court yesterday in its judgment concerning the Shiv Sena case. So you understand this very clearly. This concept of objective material directly, explicitly does not exist in the Constitution. But the governor must act with the application of his mind to look for objective material before calling for the floor test. Court also in the S.R. Bommai judgment has stated that the objective material should be such that it would satisfy a reasonable person acting in a responsible manner, sensing that the government has lost its majority. There is no definition of objective material. The governor must use his mind to satisfy himself or herself that there exists objective material to call for the floor test. So based on this, Supreme Court has noted that in this particular case, the governor has erred in calling for a trust vote. And this mistake by the governor triggered the fall of the government in the mid-2022. So from our exam perspective, the most important observation of the Supreme Court on the role of governor is this: the discretion to call for a floor test is not an unfettered discretion. So there are two things to understand here. First of all, that governor do hold some discretion for calling for a floor test, but that discretion is not unfettered. Supreme Court puts up a practical point that the governor must be aware of the fact that his very calling for a trust vote may precipitate the loss of majority for the government. So he must tread very cautiously and he must call for a floor test only when there is existence of objective material. That is one thing. In the entire judgment, Supreme Court also has made another very important point concerning party constitution, the issue of inter-party democracy. Supreme Court has observed that dissent and disagreement within a political party must be resolved in accordance with the remedies prescribed under the party constitution. The floor test cannot be used as a medium to resolve internal party disputes or intra-party dispute. Why? Because floor test is used to test the confidence of the members of the assembly in the government. It is not to be used to resolve the disagreement of the members of the assembly with the political party they belong to. The issues of political party must be resolved according to the party's constitution. So the issue of political party and the issue of government, these are two separate things. Later in our discussion, we shall take up this issue of party's constitution, inner party democracy as well. But for now, the act of the governor to call for the floor test has been declared illegal because of absence of objective material. Because the governor called for the floor test based on the letter written by the leader of opposition that certain MLA want to get out of the political party of Shiv Sena. And in the eye of Supreme Court, that is not an objective material. That perception of leader of opposition is not an objective material. Because ideally, the floor test should be based on no confidence motion brought by the opposition party. Or a group of MLA meets the governor, or they parade in the complex of the Legislative Assembly showing that they no more support the government. But the House was not in session and no such thing has happened. So it was the notion or perception of the governor based on the letter of leader of opposition, which cannot be considered as objective material. But however, at the same time, Supreme Court has also ruled that the governor was right in inviting Mr. Shinde to form a new government as Mr. Thackeray resigned before the floor test. This means when there is resignation by the chief minister, the governor is at his discretion to call any political party or coalition to claim their majority in the House. So since Mr. Thackeray resigned, so it was at the discretion of the governor to call Mr. Shinde to form the government. And hence you see here that the discretion to call for a floor test is not an unfettered discretion, meaning there are some discretions, but that discretion is not unfettered, restricted by existence of objective material and other things that we are going to talk about now. So now what we are going to cover is actually important for the exam. The rest was the background. So let's look at the role of governor vis-a-vis floor test. A floor test is a procedural mechanism for determining the majority support for a leader or party or alliance or coalition in the Legislative Assembly or for that matter in the Parliament. In the Indian polity, governors have the power and duty to call for the floor test under certain circumstances to resolve dispute over the choice of chief minister or to prevent the misuse of Article 356 and to ensure transparency. It is up to the discretion of the governor to call for a floor test under these circumstances. When the chief minister loses majority in the assembly, if the governor believes that the chief minister has lost the confidence of majority members in the assembly based on objective material, then he or she can ask the chief minister to prove majority support on the floor of the house. This usually happens when defection has happened from the political party or a no confidence motion has been brought by the opposition. When there are two rival claims to form the government from different leaders or different parties, then governor is at his or her discretion to call for a floor test to resolve the dispute and determine who has the majority support. You know that as per Article 164, Clause 2, the chief minister shall be appointed by the governor and shall be the leader of the majority party or coalition in the assembly. Article 164, Clause 2 says that the chief minister shall be the leader of the majority party or coalition. So this implies the need to determine the majority. So if the majority is not clear or there are disputes, then governor may call for a floor test to determine the choice that has the maximum support, to determine who has the maximum support. So in that case as well, governor is at his or her discretion. When there are mergers, splits, or factionalism in a political party resulting in disputes over the leadership of legislative party would mean the members of the political party in the house. So if there are disputes over the leadership of the legislative party or rival claims to form the government, the governor can again intervene and call for a floor test to resolve the deadlock. But that also has to be based on objective material, not just perception. And in case of a hung assembly, when no party or coalition has a clear majority, the governor may invite those attempting to form the government to prove their majority through the floor test. But as we have already talked about, these discretion are based on existence of reasonable material. Then there are other cases in which the governor must mandatorily call for the floor test. There is no discretion here. Before imposing precedent's rule, in the instance where the governor's report says that government cannot be formed, in that case, according to the S.R. Bommai judgment of 1994, governor must conduct a floor test to determine if the government has lost majority following the defection. Without conducting floor test, governor cannot conclude in his report that government cannot be formed in the state. So before imposing Article 356, before imposing the President's rule on this very ground, floor test is mandatory. Similarly, if the Chief Minister requests for dissolution of assembly, then according to Rameshwar Prasad case of 2006, the governor must conduct a floor test first to determine that the Chief Minister has lost majority support. To accept the request of the Chief Minister of dissolving the assembly, the Chief Minister will have to first prove his majority, and for that the floor test is mandatory. Supreme Court verdict in the Nabam Rabia case says that a governor can direct the Speaker of the Assembly to hold a floor test to determine the majority for one or other rival claimants to become the Chief Minister. And this test must be held within a reasonable period, say within 7 to 15 days. Next, we will take up the discussion on the role of Speaker as has been observed by the Supreme Court in yesterday's judgment as well. And there we will take this Nabam Rabia case again. Supreme Court has observed that the Speaker waited till the time Election Commission has given the party symbol to the Shinde faction. And until then, the Speaker did not take any decision regarding defection. So it violated the principle that the test has to be done within the reasonable period. Supreme Court in Maharashtra trust vote case of 2019 also has said that the floor test should follow principles of transparency and fairness. Supreme Court ordered for the live telecast of this trust vote back then in 2019. See, you must understand the floor tests have been instrumental in ensuring the principles of democracy, constitutional morality, and public trust in the government. They deter political maneuverings and ensure functional integrity of the institution of legislative assembly or the parliament. So it is the duty of the governor to call for the floor test. It is empowerment of the governors to ensure the objective fundamentals of Indian polity. And hence it's a duty that must be fulfilled with lots of responsibility. That is why the Supreme Court has reiterated that it must be based on objective material to fulfill the objective fundamentals of Indian democracy. So much so, if it is not based on objective material, that action of calling for the floor test is illegal. Just like Supreme Court made strong observation on the role of governor vis-à-vis floor test, the same has been done by the Supreme Court on the role of the Speaker. Supreme Court majorly has made 3 observations concerning the role of Speaker in the floor test that was conducted to change the government in the state of Maharashtra. The first and the most important observation in this regard is that the Speaker's decision to recognize representative from one of the faction as a chief whip was illegal, and if the recognition of the chief whip was illegal, all the process consequentially were also illegal. We will take a pause from this sequence of discussion concerning the incident of Shiv Sena in the state of Maharashtra and the judgment on that, and we will discuss a little bit from the perspective of our prelims examination, whip under the 10th schedule. The whip, it refers to an enforceable command issued by the political party to its members regarding attendance in the House or voting in the legislature as per the party policies. The 10th schedule of the Constitution deals with the disqualification of members for failing to follow the party whip. See, strict adherence to whips by legislative members, it is considered crucial for party or alliance unity. It is crucial for discipline and ensuring passage or blocking of bills or motions in a democratic system. And hence, defection against the whip will call for penalty. And that penalty is disqualification. Each party can appoint one member from the House as chief whip. There could be additional whips. The purpose of the chief whip or the additional whip or they together is to coordinate and ensure attendance or voting of the members of the party as per the party direction. In the beginning, I told you whip is an enforceable command. Command as per the party policy. It cannot be arbitrary. A party can issue whip only for bills and motions it has a stated policy on or it has a consensuous decision on. Whips cannot be issued arbitrarily or retrospectively. Independent members or the nominated members, obviously, they are not bound by any whips. A legislature who votes or abstain from voting contrary to the party whip in the House, he can face disqualification under the 10th schedule. But Supreme Court, via various judgment, has made it clear that whip applies only when a bill or a motion is being voted in the legislature. Not at the earlier stage, not at the stage of discussion, not when debate or introduction of the bill is happening. So the members can express dissent or opinions freely, even against the party line. So it strikes a balance between stability in the democratic system and freedom of speech of the members of the assembly. Supreme Court in 1993, in the famous Quijotto-Holland case, upheld the validity of the constitutional necessity of the anti-defection law. But it struck down one provision of this law that barred judicial review of the Speaker's decision on the question of disqualification of the members. Judicial review is part of the basic structure of Indian Constitution and it cannot be excluded from any democratic process. And you would understand the importance of this provision of Quijotto-Holland case only because of this judgment, a member disqualified under the anti-defection law can approach the court and contest that the whip was issued in violation of party procedure or the party rules, because whip cannot be arbitrary. And as the discussion proceeds, you will understand this provision of opening the door for judicial review has a bearing in this case as well. Now let's come back and read the observation of Supreme Court yet again. The court has said that the Speaker's decision of recognizing the representative from the Shinde faction of Shiv Sena as the chief whip was illegal. And it was also illegal for the Speaker to recognize Mr. Shinde as leader of the Shiv Sena legislative party. Now here comes the very important explanation of the Supreme Court as to why these two decisions by the Speaker are illegal. Supreme Court has clarified that whips and leaders of the party in the House ought to be appointed by the political party and not the legislature party. The legislature party means the members of the political party in the House. But the thing is that the Supreme Court has ruled that the decision of the chief whip, the decision on whips, and the decision on the leader of the party will be decided by the political party and not the legislature party. So it is not important which faction has more number of legislative assembly members. What is important is which faction represent the political party. There are too many things here. You have to hold your breath, hold the horses of your mind, and be patient for the pieces to fit together to see the larger picture. The entire thing is hinged on the fact that who is the chief whip. Because if the members goes against the whip, against the enforceable command, then they stand to be disqualified. So whether the whip is from the Shinde faction or the Thackeray faction, that has all the bearing of the entire voting process that happened henceforth. So the chief whip and the leader of legislative party would be decided by the political party. And who would decide the political party? Election Commission of India. But there's a third problem with the role of speaker. Let's discuss that first before we come to Election Commission of India. The third fault that the Supreme Court finds in the role of the speaker is to stay the disqualification proceedings. The speaker did it in anticipation of the decision of Election Commission of India on which of the two rival faction was the original political party of Shiv Sena. Election Commission of India was to decide as to who will hold the symbol of bow and arrow of Shiv Sena. But the Supreme Court held that the decision of Election Commission of India on the plea before it need not be consistent with the decision of the Speaker as per the 10th schedule of the Constitution. This is because the decision of the Speaker and the decision of Election Commission of India each are based on different considerations and they are taken for different purposes. The consideration of the Speaker for his decision would be 10th schedule. And the consideration of Election Commission of India are different that we are going to talk about in a short while. But Supreme Court has said that Speaker should not have delayed the disqualification proceedings in anticipation of anything. Because we already have seen in Nabam Rabia case, Supreme Court has said that the decision must be taken within reasonable period. This decision of Speaker is not contingent on decision by any other body. Also, in the beginning of the discussion, I highlighted to you that floor test is called for support of the government. Floor test is not called for the support of the political party. The issues of political parties are decided by party constitution. It will be decided on different factors, not by 10th schedule, not by speaker, not by governor. And Supreme Court has stressed more on this by emphatically saying this. There's a difference between political and legislature wing of a party. And the court has written this in the judgment to hold that it is the legislature party which appoints the whip would be to sever the figurative umbilical cord. The figurative umbilical cord. You understand what umbilical cord is? It's the crucial link between the mother and the baby. To hold that it is the legislature party and not the political party which appoints the whip would be to sever this figurative umbilical cord which connects the member of the house to the political party. It would mean that the legislatures could rely on the political party for the purpose of setting them up for elections, that their campaign would be based on the strength or the weakness of the political party and its promises and policies, that they could appeal to the voters on the basis of their affiliation to the political party, but that they can later disconnect themselves entirely from the very party and be able to function as a group of MLAs which no longer owes even a hint of allegiance to the political party. The Supreme Court clearly is saying that the MLAs, they are somehow still attached to the political party like an umbilical cord, like the baby is attached to the mother with the umbilical cord. And based on this argument, Supreme Court has ruled that whips and leader of political party in the House ought to be appointed by political party and not the legislature party. So the speaker must not just see who has the larger number in the state legislative assembly or the parliament, but must consider who is the real political party. And how to consider that? Supreme Court has made observation on the role of Election Commission of India as well in the yesterday's judgment. The court has said that it is not necessary for the ECI to rely on the test of majority in legislature alone, which clearly the Election Commission has done, and rather this is the argument the Election Commission has put forward to give the symbol of bow and arrow, the symbol of Shiv Sena, the name of Shiv Sena to the Sindhi faction. They have applied the test of majority in the legislature. But the Supreme Court is saying that this is not the test to be applied alone. And in cases like this, it would be futile to assess which group enjoys a majority in the legislature. Rather, ECI must look to other tests. Like what? Like the test of the majority in the organizational wings of the political party, or the analysis of the provisions of the party constitution, or any other appropriate test. Now, since the petition was not filed against the judgment of ECI, so Supreme Court has not given any verdict on the merit of the judgment of ECI, but it has just made observation that this is how ECI must be proceeding. And then it has said that the speaker was not ought to wait for the judgment of ECI, final decision of ECI to come. Rather, the speaker within the reasonable time frame must have taken decision based on 10th schedule, because these considerations, the test of majority in legislature or the test of majority in the organizational wing, these are the considerations of ECI. These are not the considerations of the speaker. The speaker ought to decide as per the 10th schedule. And as per the 10th schedule, the whip has to come from the political party. So the Supreme Court suggests that it is the Thackeray faction which is the political party. But now the situation stands like this. The decision already has been taken by the speaker, but that decision is illegal. So what happens now? What happens now is the speaker will take the decision again. The speaker will decide on the disqualification of MLAs that have left the Thackeray faction. Because by law, if there is no exceptional circumstance, then the speaker is the appropriate authority to adjudicate petitions for the disqualification under the 10th schedule. So the decision has to be taken again because this decision is illegal. But that decision again has to be taken by the speaker within the reasonable time frame. So the case is not over yet. However, in the judgment, Supreme Court has given a framework for the speaker based on which the decision must be done. First of all, the speaker should not just accept the defense of any faction that they are merely split and they have not defected. Their claim of split from the party cannot just be the merit. The speaker must also look at the party constitution submitted to the Election Commission of India. As per the party constitution, who is the president? That also has to be taken into account. And the judgment of the speaker must not be swayed away, must not be hinged on the numbers in the House. Blind appreciation of majority in the Legislative Assembly must not be the sole criteria for taking a decision concerning disqualification. So Supreme Court has mapped the factors for the speaker to consider while deciding the disqualification petition. So the matter comes back to the Speaker of the Maharashtra Assembly yet again. And according to some of the analysts, Mr. Navekar, the present Speaker of the Assembly, he must disqualify the 16 MLAs who violated the whip issued by Mr. Prabhu, the Chief Whip appointed by the Thackeray faction. The Chief Whip is the whip appointed by the political party, which is the Thackeray faction. So in this case, the speaker must declare MLAs going against the chief whip as disqualified. So we will now have to wait and see what is the decision of the speaker, and it will always be open to judicial review. But for now, there is no change in the government of Maharashtra. Additionally, you must also be informed that there are two issues that the Supreme Court has referred to a larger bench of 7 judges. The court has referred to a larger bench the question of whether a speaker facing removal could decide disqualification petition against MLAs under the 10th schedule. In the Nabam Rabia judgment, Supreme Court held that a speaker who was himself under a cloud should not hear and decide qualification petitions of legislatures under the anti-defection law until his own name was cleared. So the previous speaker of the Maharashtra Assembly, he could not continue and the election of the new speaker happened. And he could not also decide on the disqualification of the MLAs going to the Shinde faction. But this, according to the present wisdom of the bench of the Supreme Court that adjudicated on the matter, is against the spirit of 10th schedule. And the bench also wondered whether the MLAs facing disqualification for causing a split in the party and unsettling the ruling government, could they be allowed to benefit from a subsequent floor test? Meaning, should they participate in voting? The argument by the bench is to allow such MLAs to attend a trust vote would amount to legitimizing a constitutional sin, because someone who has defected, who has caused a split within the party, is liable to be disqualified under 10 schedule. But at the same time, if that person is liable to be disqualified, can he participate in the trust vote? Can he benefit out of his own defection? So a substantial member defects, then you change the speaker, you also participate in the voting of the speaker, so you select a new speaker and the new speaker does not disqualify you. So you defeated the system. And that is against the spirit of the 10th schedule.